1, 2, 3, 4. Here comes another knockdown for Connor McGregor. I'm Andrei Mincov, the founder of Trademark Factory, and in this video I'm going to share my thoughts about yet another trademarking screw-up. This time around, it's Connor McGregor losing yet another fight around his trademarks in Europe. Let me read from the article first, and you can always find the link in the description below. Dutch firm called McGregor objects to Connor McGregor's attempts to trademark his name. A Dutch firm is claiming that Connor McGregor's attempts to register his own name as a trademark across the EU will create confusion with its own goods. In an 8-page submission, Schiphol-based McGregor IP BV has lodged comprehensive grounds of objection against Connor McGregor's main firm, McGregor Sports and Entertainment Ltd, seeking to register the Connor McGregor trademark. The Dutch firm sells clothing and accessories under the McGregor brand and has told the European Union Intellectual Property Office at Alicante in Spain that consumers might believe that goods sold by Connor McGregor's firm are part of products marketed by McGregor IP. The Dutch firm is already opposing plans by MESL, this is Connor McGregor's firm, McGregor Sports and Entertainment. So they are already opposing plans by MESL seeking to register the McGregor Follows and McGregor Productions trademarks. The company states that it acquired the complete McGregor trademark portfolio and all other McGregor intellectual property rights on October 15th, 2017, 2 months after Conor McGregor's fight with Floyd Mayweather. So it's not that they had been utilizing this brand for decades and decades. They bought the brand from somebody else couple of months after the big fight, couple of months after all the publicity that the fight generated. And now they're saying that the attempts by Conor McGregor to trademark the brand go against their interest in the brand. Okay, so let's keep reading. The objection states that meanwhile, McGregor IP has relaunched the McGregor brand in the European market. It explained that the McGregor branded products are being sold under license from McGregor IP through bricks and mortar stores and online within the EU. The submission states, today, the McGregor brand still stands for quality, a sophisticated collegiate lifestyle, and that unique ability that America has of combining European tradition with a leisure sporting life. Okay? The objection states that the McGregor brand story started in the early 1920s with member of the McGregor clan, Scottish hat maker and entrepreneur David Doniger, emigrating to the US. The objection points out that McGregor Sports and Entertainment, MESL, was established in 2014 as a means of tapping into Conor McGregor's earnings. This article is messing me up because in half the paragraphs it says MESL and in half the paragraphs it says MSEL. So this is mean. This is really mean. So anyway, it states that based on goods and services for which McGregor's company has applied its various trademark applications, they will also design, manufacture, distribute, and sell apparel, footwear, accessories, and other products with a focus on a leisure sporting life. McGregor IP state that there is a likelihood of confusion amongst the public between the brands because of the trademark's high similarity. The Dutch firm state that the overall impression produced by the proposed Conor McGregor trademark may lead the public to believe that goods at issue derive, at the very least, from companies which are linked economically, in which case the likelihood of confusion must be held to be established. As a result, McGregor IP has told the EU IPO to refuse the application as the opposition is well-founded. McGregor IP has also requested the EU IPO that it be awarded its costs. The Connor McGregor firm can now reply to the grounds of objection raised by McGregor IP, and a decision is expected on the application before the end of the year. Last year, McGregor's plans to obtain a trademark for his planned Notorious whiskey came unstuck after he withdrew his trademark application for the whiskey in the face of opposition from a Carlo brewer who had already secured the trademark for Notorious. McGregor subsequently launched his whiskey, settling on his second choice name, Proper Number 12, for the brand. All right, so a few things. First of all, in Europe, trademarks are only protected after you register them. There's no such thing as an unregistered trademark. In Europe, they don't recognize common law trademarks. They don't recognize years of use of your trademark. They don't care. The only way to protect the brand in Europe is to apply for and register your trademark. That's the first comment. Second comment, like I said, this new company bought the rights from the old company and looks like there was barely any use by the time they bought it. And now they say, no, we've revived the brand, so there's active use now. Guess why they're doing it? They're doing it to avoid any allegations from Connor McGregor's firm that there is no use of the brand by the plaintiff, by the opponent, so if there was no use by the opponent, then there would be grounds for cancellation of that trademark. So they say, no, there is active use here. Brick and mortar stores, here's online sales. So they are covering their assets by saying, yeah, there is active use. And it's not difficult to show active use when you're playing a big game like these guys are. So here's what they do. They find out about the big match. They realize how much money it's going to generate. They look up the trademark register. They realize that Connor McGregor did not secure his assets, did not register his trademark, has not even applied for a trademark, and they do what any good troll would do, and they go after the trademark application after Connor McGregor files his trademarks, and now they're opposing them, and they have a decent case of winning because again, a lot of how Europe looks at trademarks is very formalistic. Who was the first to run to the trademark registry, right? Is the assignment valid? Is there active use? Yes. When did Connor McGregor file his trademark? After. So there would be quite an uphill struggle for Connor to win that opposition. Probably, really, it's not about opposition. It's not about, the genuine use of the brand. What they're probably looking for is for Connor to make them an offer they would not refuse. Basically, pay them off for them to go away with their opposition so that Connor could use and own his brand in Europe. This is my reading of what's going on here. The big lesson here is that it would have been infinitely easier and cheaper for Connor McGregor and his company to own the brand in Europe before the big fight. Really, the best time to file for your trademark is when you're the only person out there who sees the potential value of your brand, before the value of your brand has been established, before the value of your brand is seen by the world. Because it's not just about your potential fans, it's not just about your competitors, it's also about trolls who, that's all they do. They look at up and coming brands, then they check who's trademarked and they attack those who aren't. And oftentimes it's too late by the time you realize that, oh, we want to own this market and it's taken. So the best time to protect your brand is when you realize you got something coming for you and you make sure you own your assets. This is what Connor should have done. This is how he would have gotten around all of these oppositions, all of these disputes, all of these refusals, all of these rejections, all of these rebrandings. This would have been 1,000 times easier and probably even more times cheaper. But things are what they are. It would be interesting to see how this situation is resolved. Of course, we're going to follow it and report when we know the new details. Now, if you found this video useful or interesting, make sure you subscribe now, get notified whenever the next video goes live. If you got a brand that you want to protect, but you got to protect it early, right? If you realize you want to protect your brand and it's already taken, well, guess what? It's too late, because with trademarks, as I often say, it's never too early, but often too late to protect your brand. So if it's already taken, you're kind of done here. So if you want to protect your brand and it's not too late, go to trademarkfactory.com and book your call with strategy advisors. And by the way, if you don't know if it's too late or not too late, still go to trademarkfactory.com and book that call, because once you become the client, the first thing we're going to do is we're going to check and see if your brand has a chance of going through. And if it does, great. We're going to do whatever it takes to make sure that you end up owning that brand. And if we see a problem with registrability, we're going to get back to you, and you may get a full refund unless we, together come up with some creative ways to get you to own the brand or a brand if you have to change into something different. But it all starts with a proper comprehensive trademark search, during which we give you the chances of it going through. And if you don't like the chances, you can always get all your money back. Simple as that. So here's your simple checklist. If you haven't subscribed yet, subscribe. If you got a brand that you haven't protected yet, go to trademarkfactory.com and book your call. And until then, I will see you in the next video.